Right. Thank you, Mr. President and members. At this time, I move to suspend the regular order of business to take up and consider the committee substitute to Senate Joint Resolution 1. Members, it is undeniable that our state has experienced a significant increase in illegal immigration in recent years. Unfortunately, the surge has also led to cases where illegal immigrants have committed serious crimes against Texas residents, with insufficient mechanisms in place to detain those who pose a considerable flight risk. Recently, President Trump signed the Lake and Riley Act, directing the United States Attorney General to take custody of any illegal alien charged, arrested, convicted, or who admits to committing certain criminal offenses. To support the federal government in implementing this law, Texas needs to establish comparable detention measures for illegal aliens accused of felony offenses. Specifically, the committee substitute to Joint Resolution 1, if approved by Texas voters, would amend Article 1, Section 11 of our state constitution to require the denial of bail for an illegal alien who is accused of a felony offense upon finding of probable cause. The definition of an illegal alien in the resolution aligns with the federal definition of an undocumented criminal alien. Under this mechanism, a judge or magistrate setting bail must first determine that probable cause exists to believe that a person engaged in the conduct constituting the felony offense. Most importantly, this joint resolution is named after a young girl named Jocelyn Nungare, who on the night of June 16, 2024, was sexually assaulted and murdered in Houston by two illegal aliens from Venezuela. To make matters worse, these two men were not denied bail for the murder of Jocelyn, even when the preponderance of the evidence that existed at arraignment and the fact that their illegal alien status presented a major flight risk. If these men had had the financial means, they could be out on the streets today. As we know, there are many alleged murders out on the street in Harris County and in the state of Texas. And members, this is just unacceptable in our state. I was heartbroken, and I'm sure many of you in this room were in the committee and heard Jocelyn's mother describe how it was simply a slap in the face for having to go to court while grieving and making funeral arrangements just to plead to the court that these men not be released on bond. Members, we need to remember that our first and foremost duty as legislators is looking out for the safety and well-being of the citizens of Texas and the constituents that elect us. The committee substitute to SJR shows the state's commitment to protect our citizens and assist the federal government in their efforts to prevent violent illegal aliens from terrorizing our communities. And I'm happy to answer any questions.
Senator Hinojosa of Hidalgo, for what purpose?
Senator Huffman, yield.
Senator, do you yield?
Of course, yes.
Thank you, Senator Huffman. I just want to clarify a couple of points.
Okay.
As I understand, the bill only applies to felony offenses.
That is correct.
And one of the issues that we face in terms of public policy and the criminal justice system, we have many jurisdictions where a illegal alien or undocumented person can be charged with a felony, but yet they can have a magistrate or a JP set bond.
Yes, and I believe that is happening routinely throughout the state. And in the Valley, I know it is happening, yes.
And that's an issue because they've been accused of a felony and they're with the JPs or with the municipal court magistrate. Many of them are not working necessarily with immigration to be able to access, find out if there's a detainer on that particular defendant.
That is correct, yeah.
And one of the issues, in many respects, we have jurisdictions where the sheriff department is working with immigration to make sure that there is a detainer placed on a person who's undocumented who commits a felony, and those people can be held.
That's correct. And as you know, and some of our counties do participate in the 287G that makes them, in effect, federal immigration officers or the power to place detainers and get the information. I know Senator Schwartner is working on a priority bill, can't remember the number right now, to mandate that for some of the counties that, at least to apply to become one with the feds, that are not currently participating, because some of our larger counties that most need to participate, like Harris County, like Travis County, do not participate in the 287G. So this bill, if passed and approved by the voters, would fit nicely with these provisions that would require more cooperation with the federal government in actually identifying who is detained.
And actually, we have cases throughout the state of Texas where you have had a defendant who is in this country illegally commit a crime of violence, and even though there's a detainer, a magistrate or a judge will still provide a bond because the law doesn't mandate or require that a bond be denied if you are in this country illegally and commit a felony.
Correct. So this would be would require the judge to place a no bond for those. Once it was proven that they were illegal, whether it be through checking their criminal background, through the 287G affirmation, or sometimes they self-report that they're here illegally. As you well know, they voluntarily say, I don't have a driver's license, I don't have an address, I'm just here. So once that's determined and probable cause that a felony has been committed, then the judge shall detain them.
And one of the issues that I've had come up and be asked on the standard that the probable cause, you have to have probable cause to be able to deny a bond to someone in this country illegally.
Correct.
But on the probable cause, you do require evidence to be able to establish probable cause.
Correct, yes. And judges sometimes make findings that there are no probable cause, as we well know. But yeah, it's a basic determination for probable cause to exist, does exist, that a felony has occurred.
And here we're focused on trying to make sure we protect the general public over what is nowhere has happened in the past, where you've had gang members from Venezuela and from cartels and other people who committed crimes in other countries that are unfortunately many times are let out on bond, even though they're in this country undocumented.
Right, and Senator Hinojosa, I'm sure you would agree with me that it's fairly common to see individuals who have been deported on 2 or 3 occasions in the past, which also show up when you run these background checks, and yet are here in the country alleged to have committed a felony. So these are also the type of individuals who are currently being released oftentimes, but would not be able to be under this legislation.
Well, thank you for your bill. And I think we as public officials and senators owe a duty to protect our citizens from violent criminals who are in this country illegally. Thank you.
Thank you,
Thank you,
Senator
Mr. President.
Senator Huffman moves suspension of the regular order of business. Is there objection? Hearing none, the rules are suspended. The chair lays out on second reading committee substitute for SJR 1. The secretary will read the caption.
Committee Substitute SJR 1, proposing a constitutional amendment requiring the denial of bail for an illegal alien charged with an offense punishable as a felony.
Senator Huffman, you're recognized for a motion.
I move passage to engrossment.
Members, is there any objection? Hearing none, the committee substitute for SJR 1 is passed to engrossment. Senator Huffman is recognized for a motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Senator Huffman moves suspension of the 3-day rule. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagenby.
There being 31 ayes and no nays, the rule is suspended. The chair lays out on third reading and final passage committee substitute to SJR number 1. The secretary will read the caption.
Committee Substitute SJR 1, proposing a constitutional amendment requiring the denial of bail for an illegal alien charged with an offense punishable as a felony.
Senator Huffman, you're recognized for a motion.
Members, thank you for your votes. Jocelyn's family thanks you, And in memory of Jocelyn, I move final passage of the committee substitute to SJR 1.
Senator Johnson, for what purpose?
Brief statement on the bill.
I'm sorry, could you repeat that?
Brief statement on the bill.
You're recognized.
Thank you, Mr. President. Thank you, Senator Huffman, supporting the cause, recognizing the need. I do want to make a comment for the record that this is a very broad bill. I think it stands a chance of having constitutional problems, and that in working with such breadth, we may wind up with no bill whatsoever. Nevertheless, it may pass constitutional muster. We are addressing a need, but I think we would be well advised to consider constitutionality with everything we do, and sometimes we go a little too broad through the legislative process in working with the House. There may be an impetus to narrow the scope of this somewhat, and I think we should all take a look at that if and when that time comes. Thank you.
Senator Huffman, you're recognized to close on your motion.
I move final passage.
Senator Huffman moves final passage of committee substitute for SJR number 1. The secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton, Earhart, Flores.
There being 29 ayes and 2 nays, the bill is finally passed. The regular order of business on committee substitute to Senate Bill number 9.
Thank you, Mr. President. Members, at this time,